In the matter of Shanti and others versus National Insurance Company, the Supreme Court allowed the appeal and modified interest rate from 6% to 12%. It was the submission of the counsel for the appellants that there is a statutory mandate to award interest under subsection 3A at the rate 12% per annum, and the discretion conferred on the commissioner is only to the extent of granting a higher rate, which again should not exceed the lending rate specified for scheduled banks. The standing counsel for the respondent insurance company refuted the claim on the contention that the insurer is not liable to indemnify the insured for the default committed by the insured. It was pointed out that in the present case, the owner of the vehicle was the father of the deceased, and the contention was that the deceased was employed as a cleaner in the truck owned by the father. The mother and the other siblings were the claimants. There is a specific contention taken by the insurance company that there was no intimation about the accident given to the insurance company. It was submitted that even if the liability is mulcted on the insurance company, they are entitled to recover the interest awarded from the insured, since there is no question of indemnification of a default committed by the employer. Supreme Court said that we cannot but notice that under section 4A3 the interest liability arises on default of the employer in paying the admitted compensation due under the act within 1 month from the date it fell due, and if there is such default, necessarily interest shall run at the rate provided. That the interest runs from the date of the accident is declared by the court in Pradeep Narayan Singh Deo versus Srinivas Sabate and Northeast Karnataka Road Transport Corporation versus Sujata. The legislative intent is very clear insofar as subclause B of 4A3 conferred a discretion on the commissioner to impose a penalty not exceeding 50% of the amounts awarded, while no such discretion is available under clause A. In the instant case, the commissioner had awarded only 40% penalty. The question of whether the son's employment in father's vehicle can give the benefit of the legal representatives to raise a claim for compensation under the Act cannot now be agitated. The claim petition was once dismissed on the ground, and the claimants had approached High Court. The appellate order found the claim to be maintainable and directed a fresh consideration based on the evidence led as to the employer employer relationship. The commissioner under the Act had considered the evidence and found the employer employer relationship to be in existence, leading to the award of compensation with 6% interest per annum and also further 40% as penalty for the default committed. The court noticed specifically that the insurance company was impleaded, claim petition, and the direction was also given to non-applicant, the insurance company, to pay the compensation, interest, and penalty, and there was no appeal filed by the insurance company against the said order, and hence there cannot be any claim raised as of now for recovery of the interest amounts it is made liable under the award. There was no appeal or cross appeal filed by the insurance company against the 6% interest awarded, and in that circumstance, in a further appeal by the claimants filed before the court, the insurance company can neither wriggle out of its liability to pay the interest amount as flowing from the award, nor can it claim recovery from the insured.